Hello everyone and welcome to today's Mondac webinar in association with Global Law Office, discussing China's new regulatory regime for data exporting and what you need to know. My name is Dan Sampaio and I'm joined by the brilliant Vincent Wang to take us through today's discussion. Vincent is a law partner of the firm working in its Shanghai office. Vincent focuses his practices working on multinational businesses and cross-border transactions in a broad spectrum of industries. He's particularly skillful in providing innovative solutions and regulatory advice in telecommunications and internet businesses, high technology businesses, cybersecurity and data protection, and digital assets regulation. Now, before I hand over to Vincent to begin today's webinar, a housekeeping item. You can submit questions to Vincent by typing them into the questions pane of the toolbar on the right-hand side of your page. We will endeavour to answer as many questions as possible, but please do reach out after the webinar for any additional information you may require. It's now my pleasure to hand you over to Vincent to begin. Thank you.
Thank you, Dan. Good morning, good afternoon, and good evening. Welcome to the webinar. Today, we will talk about China's regulatory mechanism for data outbound transfer. In today's discussion, we will talk about 4 parts. We will divide our discussion into 4 parts. Next slide. In part 1, we will talk about the background and overview of the regulatory mechanism. In part 2, we will give introduction of each of the mechanism. In part 3, we will talk about things you may want to do and not to do for those mechanisms. In the last part, we will share what you may want to consider if you need to prepare for one of the mechanisms. Go to next slide. Before we kick off the legal discussion today, I want to share with you some culture thing. Why the culture thing first? Because understand the culture thing will help you to understand the standing of the Chinese authorities in their law enforcement or administrative practice. One question, what is the famous cultural sign of China? That's the Great Wall, right? So what does the Great Wall stand for? Defense. What does that defense for? Security. So under the Chinese culture, the best way to defend security is through territory defense. That's why we had the Great Wall in the ancient time, and we had the Great Firewall in the modern time. And in the digital world, we create something new. That something new is the one we're looking at in this slide, cyberspace sovereignty. That was initially brought up by the national security in 2015 without further elaboration. It's the concept substantiated in the following 3 laws. First is the cybersecurity law in 2017. Second is the data security law in 2021. Third is the personal information protection law in 2021, December. So for the sovereignty defense, the cybersecurity law mainly defined the security from the infrastructure perspective. For example, it established a multi-layer protection scheme, which essentially categorizes different networks in China into different security levels and provides the security measures applicable to each of those levels. Secondly, it established a cybersecurity review process where the network operations that impacts the national security will be reviewed before they are implemented. That's the core reason why DD got punished, because DD, go to get listed in a foreign stock exchange without going through the cybersecurity review. The third thing in the cybersecurity law is kind of interesting. I note here that is the CIIO localization requirement. From today's perspective, that may not be a pure localization requirement, but at that time, because the thing that has been defined has not substantiate what the definition, the term means. So that was deemed as a localization requirement at that time. Under the data security law, it categorized the data into three categories: the core data, the important data, and other data or normal data. The core data is subject to a legally defined localization requirements, which is the core data should not be outbound transfer outside of China. The important data is defined as a special, group of data, outbound transfer of which will subject to the review. The normal data can be outbound transfer on free basis, but however, there's something else we need to watch for. We will talk about that in the later slides. The data security law also defines the export control mechanism for data, which essentially is data relating to the controlled item are subject to the control. Third, the data security law also established some restriction to respond to the data requests from the foreign judicial and law enforcement agency on the Chinese data processors for their data processed in China. Lastly, the law reserved for the Chinese government to launch countermeasures against discrimination treatment against the Chinese data processors. The third law, PIPL. PIPL largely following the pattern of the GDPR. Therefore, it has a similar provision on the extraterritorial effects, which governs foreign data processors that sells products or services to Chinese individuals, or data processors which monitors the behavior of the individual in China on cross-border basis. Similar to the GDPR, PIPL also categorized the personal information into sensitive personal information and normal personal information. For security purpose, PIPL borrowed the same concept as to the restriction on the response to the data request from the foreign judicial and law enforcement agency, and also reserved Chinese government countermeasure against discrimination treatment. These are basically the fundamental legal basis for the data outbound transfer mechanism. So you may understand, to tackle the data outbound transfer regulation, we need to understand security, particularly defense in security is part of the approach used by the regulation and the regulators. Next slide. So what are the regulatory mechanisms? They are the data outbound transfer security assessment, the personal information outbound transfer standard contract, that is the China SCC. Lastly, personal information outbound transfer security certification. Note that only the security assessment bears the title data, and the other two mechanisms bears the title personal information, which means the security assessment covers both the data and the personal information, while the China SCC and the security certification focus on personal information outbound transfer only. Next slide. So who will be impacted by the regulatory mechanism? The parties that may be impacted by the regulatory mechanism includes data processors in China, of course, but also it includes data processors outside of China, which is subject to the PIPL. Thirdly, it will impact the foreign data recipients who receives the data from the Chinese data exporter. Lastly, it will also have impact on the indirect foreign data recipients which receive China-sourced data from the direct foreign data recipients. Why? Because under both the security assessment and also the China SCC, there's a requirement that when the direct foreign data recipient wants to forward, transfer, or subcontracting certain processing activity to a third party, they need to make sure their obligation under the legal documents will be transferred or committed by the indirect foreign data recipients. And they will be held liable if there's any breach or violation of the law by the indirect foreign data recipients. So that's the reason why. Next slide. Then what type of data that will be impacted? As we discussed, we already discussed the 4 types of data under our introduction of the data security law and the personal information protection law. Those data are core data, important data, personal information, and other data. And here you see there are 3 types of data. I didn't include core data in this slide. That's because I said core data is subject to localization requirement. There's no way anyone can outbound transfer any core data outside of China. Important data is the type of data that may have impacts to the national security or public interest. Currently, there's impossible for a data processor on its own efforts to determine what important data it may have, unless one, it receives a notice from the regulatory authority informing the certain type of data it process is important data, or it receives legitimate notice from the third-party data provider, which provides the data to the data processor and notify the processor that the data provided is important data. What is the reason for such an awkward recognition mechanism? Because under the current law, we have established a mechanism to determine the important data, but the mechanism is still in developing and the implementation has not been fully fulfilled. The mechanism is that the regulatory authority of the industry and the local governments will establish the high-level guidance to determine important data. With the high-level guidance to determine the important data, the provincial office of the industry regulator and the local governmental agency will release more detailed implementation rules to determine the important data. With those detailed determination rules, the data processor will be able to identify and compile important data list by themselves. And once that has been done, they will need to file the list with the local industrial regulator or the local government agency. Once the list is filed, then the important data by the data processor has been identified. However, because many industrial regulator and the local government had not released the high-level guidance to determine the important data, so the process has not been fully implemented. It may take some time, but we expect that process will be accelerated, and within this year to next year, we will see lots of high-level guidance, and also some of the local office and the local government agencies will release the implementation rules. So, but it's not the reality for the moment. So that's why, if a data processor, they don't receive any notice from either the regulatory authority or the data provider, the data is important data. There's no point for a data processor to be accurately claim or determine what type of data at a process. as important data. The second one is the personal information. We will talk about how the personal information will be impacted in the discussion of the threshold. The last one is the other data or the normal data, which are essentially non-important and non-personal data. And why it may still be impacted, because even if it will not directly impact by the three mechanisms we're discussing today, there's still industry regulations which may require on project basis review of the export of those data. These are the regulation we need to pay attention for when we are outbound transfer of certain types of the data outside of China. Next slide. Then what is the outbound transfer of the data? The outbound transfer happens when a data processor in China stores the data at a process in infrastructures outside of China. It happens when the data processor transfers the data at a process to a foreign recipient. It also happens when the data processor allows a foreign business partner, a party, or individual to remote access the data processed and stored in China. So these are all outbound transfer of the data. Next slide. So after we understand generally what are the outbound transfer and who will be impacted, let's talk about the threshold. The threshold is basically, we're discussing the threshold for two purposes. One, we understand what are the thresholds. The second, we understand how it works. Let's talk the second first, how it works. It works in such a way that if you hit the threshold, you will be subject to the security assessment. If you do not hit the threshold, you can rely on the China SCC to outbound transfer of the personal information. So let's look at the detail of the threshold. There are three categories with one catch-all clause. The first category is a special category data, which is important data. It means if any data processor outbound transfers important data, such outbound transfer will need to go through the security assessment by the CAC. The second threshold is about a special entity, which means if the data processor is a critical information infrastructure operator, or if it's a personal information processor that has more than 1 million individuals' personal information, any piece of information outbound transferred by such a data processor will be subject to security assessment. The third threshold is calculated on a time and a scale basis, which is if a data processor outbound transfers 100K data subjects' personal information or 10K sensitive personal information from last January 1st till now, such a data processor will be subject to the security assessment. If you are hitting any of the threshold, you will be subject to the security assessment. If you do not hit this threshold, you can rely on signing the China SCC and go through the proper process to outbound transfer the personal information. Next slide. These slides basically present you a logical tree to determine what type of entity or processing is subject to the security review. First, we identify whether a data processor has circumstances to outbound transfer of the data. If it does, we first look at whether the data processor is a special entity. That is, whether it's a CIO or it's a personal data processor that has 1 million data subjects information. If it is, then even one piece of information will be outbound transfer. That piece will be subject to the security assessment by the CAC. If the data processor is not the special entity, then we will look at the type of data that will be outbound transfer, whether it is important data. If it is, then it will subject to the security assessment. If not, then we will need to calculate on the time and the scale basis of the outbound transfer. If it meets the threshold requirement, the outbound transfer will subject to the security assessment. If it is not, then the data processor can choose between the China SCC or the security certification for its outbound transfer. In addition to those, processing, if the data is core data, then there's no way, there's a localization requirement, the data should not be outbound transferred. For data that is not personal information and is not important data or core data, it can be freely transferred under those three mechanisms. However, as I mentioned, there are regulatory requirements on industrial basis, which may impose on project basis review of the data transfer. You may need to watch for that, before you freely transfer the data, the other type of data. So this basically concludes our introduction of the background and overview. Next slide. We're going to discuss the regulatory mechanism one by one. We start with the first, the security assessment. Next slide. What you need to know about the security assessment. First, there are two key points in the timetable. The security assessment rule took effect on September 1st, 2022. It provides a 6-month correction period, which ends March 1st, 2023, the beginning of this month. What is the correction period it offered for? It is offered because this is a new process, and the data processor, which outbound transfer on an ongoing basis, the data needs to comply with their outbound transfer to prepare for the application. So it gives a 6 months period. Then you may have a question, the 6 months correction period has passed. What I'm supposed to do if I'm eligible for the security assessment? Theoretically, if you cannot submit application before March 1st, you are in violation. But however, because this is a new regulation, and also because the potential impact of the security assessment has a huge, effects to a large group of data processors, including, state-owned, private-owned, and foreign invested entities in China. Therefore, currently the CAC, based on what we were told and what we heard, the CAC basically says it will not, at this stage, enforce the outbound transfer requirement to stop outbound transfer requirement for processors that has not submitted application. As long as those data processors are diligently prepare for the assessment, are seeking help to do the preparation, and they will not enforce harshly against those processors. Secondly, the headquarters of CAC announced the first two cases that passed the security assessment. The first case is a Beijing hospital that has an international clinical trial program with a hospital in Holland. The second project is the personal information and freight related, data transportation by Air China. These are basically the essential information and the business exchange between Chinese entities and foreign business partners. And, therefore the government takes great efforts to help the compliance of them and, approve them as two first cases. As of today, as far as we know, there are more data processors application has been approved, including the application by the foreign invested entities in the manufacturer business and in the retail business and in some other business. Next slide. So these will give you some information regarding the current status of the security assessment based on the information published by the local office of the CAC. On top of the slides, it is based on the public announcement by the Beijing office of the CAC. As of the end of February, it has received application for security assessment from 48 applicants. And it has requested 35 applicants to supplement their application. And 11 applicants' application has passed the formality check by the Beijing office. They are on the way or reviewed by the CAC headquarters at the moment. In addition to the numbers, the Beijing office of the CAC also released examples of the applicants, which includes Amazon, BMW, Samsung, and all other names I listed here, which are in the public announcement of the Beijing office of CAC. As a comparison, the Shanghai office of the CAC also released its own data. At the beginning of March, it has received applications from 270 applicants. And its hotline has answered more than 2,100 inquiries about the security assessment. And it has held 6 conferences for private policy explanation on invitation basis. Not like the Beijing office, the Shanghai office only released the industry where those applicants come from, which are in retail business, automotive business, financial service business, and pharmaceutical business, and some others. So this gives you the sense, the current status of the application status. According to the threshold, as we can imagine, there will be much larger group that will go through the security assessment. But so far, these are the numbers that has been published, which basically means a larger group of the data processors are still considering preparing for their applications. Next slide. So who will involve in the security assessment? Under the law, the assessment at the headquarters of the CAC will mainly done by the CAC, but with the involvement of the industrial regulators and the provincial office of the CNC, and also some designated institutions. But in practice, based on what we heard, the CAC basically relies on its provincial office and also the government affiliated institution to help them to review the initial application of the security assessment. The involvement of the industrial regulator in the process seems not very high. Then for such a assessment involvement, there may be question, if I pass through the cybersecurity review, do I still need to go through this data outbound transfer security assessment? The answer probably is yes, because the cybersecurity review has a very different purpose. The cybersecurity review only review the potential impact to the national security and some public interest. It has an overall review of both the data outbound processing and also the China domestic processing. And the focus is the general processing, all the activities by a data processor, while the security assessment is focused on the outbound transfer of the data and about the foreign recipients' capability to protect the data that has been outbound transferred. So they have different, review mechanism. That's why, a data processor, even though it passed the cybersecurity review, may still needs to go through this security assessment. Although passing the cybersecurity review will give more credit, make it easier for the same processor to pass this security assessment. Some other people may ask, if I have already obtained the industrial regulator's approval on my projects to transfer data outside of China, do I still need to go through this CAC-led security assessment? The answer is yes. Use the human genetic resource data as an example. Under the Chinese law regulating the human genetic resource data, the Science of Ministry has the responsibility and the power to review and approve or file for records the export of the human genetic resource data from China to foreign countries. But it is on project basis, and it focuses only on the project, the impact to the project. But however, the security assessment is basically review the same processor for its overall outbound transfer of human genetic resource data during a certain period from last January 1, for example. It has a different scope of the review. Therefore, they couldn't replace each other. So that's why, even though one data processor has obtained either the approval or has filed for record of the human genetic resource data by the Science Ministry, it may still need to go through the security assessment. Although such a data processor can disclose to the Ministry of Science, to the CAC, that it has obtained approval or filed for record with the Ministry of Science, that will give credits to pass the security assessment. Next slide. Then let's talk about how long it may take. These slides basically is a flow chart we prepare based on the provision of the security assessment rules. So as you can see, the review itself may take more or less 60 working days, which is about 3 months. In practice, our experience is that the actual time from preparation to receiving the final results takes anywhere from 4 to 8 months, which echoes, more or less this time frame, because there's still, in our, work scope, the data processor needs to do some preparation before filing the application, and also there will be back and forth during the review. So that's basically, it takes longer than the statutory limitation on time, but it's more or less echoes the requirements. So companies which is subject to the security assessment needs to prepare well ahead of the time, because for multinational companies, there will be lots of internal communication to do for the mapping of the data and for some correction measures implementation. it takes time. Next slide. Then what may happen if I pass the security assessment? If a data processor passes the security assessment for data outbound transfer, it may continue in peace, transfer outbound the same data in the next 2 years. But however, there are circumstances where the security assessment needs to get redone during the 2-year period and after the 2-year period. During the 2-year period, if there's any change to the outbound transfer, for example, if the category of data has changed, or if the scale of the data has been changed, or if the storage time in the foreign country has been extended. These are all the changes that may trigger to reassess the security of the outbound transfer. The other situation, you may need to reassess the security of the outbound transfer is if there's any change on the side of the foreign recipient. For example, if there's any change of control on the side of the foreign recipient, or if there's any laws, regulations, and a security environment change on the side of the foreign recipients that may impact its capability to protect the security of the outbound transfer data, then the assessment may also need to be redo. There's also one special situation, which is the CAC may call off the data outbound transfer if it determines the outbound transfer by a specific data processor no longer meets the requirement established in the security assessment. So if there is such an order and if the data processor wants to resume the outbound transfer, it needs to redo the security assessment to address the concern of the CAC. Those are circumstances where you need to redo the security assessment. Upon the expiration of the 2-year term, if the data processor continue hitting the threshold, then it needs to redo this security assessment for another 2 years. Oh, by the way, the 2-year term does not start from the date you receive the approval. It starts from the date of your self-assessment report. So next slide. That concludes our introduction of the security assessment, and we are discussing the China SCC from this slide. Next one. What you need to know about the China SCC is, number one, it cannot be modified. Not like, even though the China SCC follows the pattern of the EU SCC, the Chinese regulation basically says, the data processor has to adopt the China SCC without any modification. Supplements are required, but the supplementary terms must not be in conflict with the main text. Number two, the China data processor, after signing the China SCC, needs to file for record with the local office of the CAC of the executed China SCC. So this is also our administrative requirements that is different from the practice of the EU SCC. Number three, the data processor is allowed to transfer the data after the contract, not after the filing for records. Lastly, when a data processor needs to redo the process of the China SCC, those circumstances are the same as the circumstances we discussed when a data processor needs to redo the security assessment. Next slide. So let's look further about the structure of the China SCC. As I mentioned in the previous slides, China SCC basically follow the pattern of the EU SCC. If you take a close look of the provisions of the China SCC, you will find many familiar clauses because some of the clauses are direct translation from the EU SCC. But however, there are more details, reflecting the Chinese requirements for security. And those are basically the main differences. A high-level major difference is when you look at the China SCC, you will note that when the Chinese government invent its own SCC, it's mainly borrow the controller-to-controller clause and the controller-to-processors clause, and it did not borrow the processor-to-controller clause and the processor-to-processor clause. And the consideration, as you can imagine, is also for security reasons, because the Chinese authorities wants to hold the in-China processor accountable for the outbound transfer. That's why they basically, assume the China processor, China data exporter, are the controller, and therefore they will hold them accountable. And however, there is certain circumstances where the China data processor are truly only a processor under the GDPR. Then how to address that situation? We will watch and see. And a possible solution is you can have supplemental terms to address that, as long as those terms are not a conflict with the main text. And I think that will subject to a case-by-case discussion and analysis with the CAC and according to the circumstances. Next slide. I'm sorry, the slide seems frozen, but okay, it's moving. So after looking at the structure, I basically present to you the obligations imposed on the data exporter and also the data recipients. As you can see in this slide and the next slides, there are 10 types of obligations imposed on the data exporter. And the next slide, there are only 5 types of obligations imposed on the foreign recipient. And you will find similarities between these obligations with the GDPR SCC. However, as a foreign recipient, you may pay attention to certain Chinese legal character under those obligations. For example, there are special requirements regarding the forward transfer and the contracted processing. And also, in the data, personal information protection obligation, there's a special requirement regarding the incident response procedures. And also, in the part regarding the data subjects' rights and interests protection, there's a special requirement on automated processing, which is quite unique under Chinese law. So we will not go into the details of these obligations, but I just give you a highlight so you may be able to go through those, standard contractual terms when you have a chance, and then you can look at them. Go to next slide. So the very last part of the China SCC is the governing law. No surprise, it should be PRC law. And as to the dispute resolution, you can litigate in Chinese court or you can arbitrate. In terms of the arbitration, you can arbitrate with the Chinese institution. The standard contracts defines 4 Chinese arbitration organizations that can take cross-border data transfer, disputes. And also you can bring it to the lawful arbitration organization in any of the signatory countries to the New York Convention on Arbitration Awards, Recognition, and Enforcement. So these basically are the introduction to the China SCC itself. Next slide. After we introduce the China SCC, we go to the very last slide, a very last mechanism, which is the security certification. Next slide. What you need to know about the security certification is not like the previous two mechanisms. The certification is conducted by a Chinese certification institution rather than the governmental agency. But the institution needs to be designated and approved by the CAC. And currently, there's already one, and we are about to see the second and the third. So far, all of them are affiliated with the Chinese governmental agencies. Second, this certification process is not mandatory, it's optional. For your easy understanding, the security certification process basically mirrors the BCR, Binding Corporate Rules, under the GDPR. So at targeting the MNC corporate groups, to go through such a process so that they don't need to file and sign many China SCC and file records with the local office, those many China SCCs. These are the benefits, but however, you may want to know that, for a foreign MNC to go through this process, the MNC corporate group needs to designate an entity in China or an agent in China to submit the application for them to go through the certification. And the most important part is the party that submit application will be held liable for any violation by the MNC corporate group in the future, data processing, which basically rule out any third-party agency service to serve the agent role in such a process. The very last, thing you may want to know what the institution will focus in the certification. It will focus, number one, on whether the MNC corporate group or the foreign processor can offer the same level protection of the personal information as that under the PIPL. And it will also, ensure that the applying MNC corporate group or the foreign processor subject themselves to the jurisdiction and the law of the PRC, and also follow the supervision, accept the supervision of the institution. There's a note that, the certification institution in China, based on their practice, tend to, review the processing activity based on the recommended, national standards. Those national standards are, best practice. So which basically means their review standards may be higher than average in compliance. So these are something you may want to consider when you decide whether you want to go through the certification. The very last part is, as I mentioned, it wants to make sure there will be an entity in China that will assume the liability for the applying MNC corporate group or the foreign data processor for easy law enforcement activities. Next slide. So after the introduction of this certification process, I think you may already have the answer whether you want to go through that or not. And that's an individualized decision, and we don't need to elaborate that decision here. Next slide. So after our discussion of those three mechanisms, you can see that, basically, all the data outbound transfer activities will be, impacted. We summarize the usual, circumstances for outbound transfer by any business in this slide, so you can see the potential impact of those, regulatory mechanisms. Next slide. In this slide, we summarize for you a comparison chart for those three mechanisms. Other than the first line conditions, which is some kind of summary and notes by ourselves, the other lines are basically prepared and in accordance with the law. So these are basically some useful information you can look at when you have a time. Next slide. In this part 3, we will talk about the things you may want to do and you do not want to do for those regulatory mechanisms. Next one. The thing we want to discuss first is about the self-assessment under the security assessment. The self-assessment is required by the PIPL. You may familiar with a different term of it, which is the PIA or PIPIA, the Privacy Impact Assessment or the Personal Information Protection Assessment. But the outbound transfer, data outbound transfer, is the only circumstances where this PIPIA requirement got elaborated. Next slide. So in these slides and the next slides, we are prepared for you a line-to-line comparison between what the law requires you to cover for the self-assessment report and the CAC's assessment. As you can see, most of the issues that needs to be covered by both are similar to each other. This basically indicates that in preparing for your self-assessment, you need to cover every issue following the Chinese law and address the Chinese regulatory concerns. If you have a good self-assessment reports that can address the regulatory concern of the CAC for your outbound transfer, the chances are higher for you to pass the CAC assessment. So therefore, the self-assessment is very important. But in order to have our good self-assessment report, you need to have a very thorough data mapping following the Chinese law. Next slide. And other than the security self-assessment, and you may want to know that for the security assessment, there's no statutory requirement you have to adopt the China SCC for the security assessment. You can use whatever you have for that purpose, but you may want to make sure what you provide to the CAC covers all the key issues that are listed in these slides. For example, if you have a GDPR style SCC, you can use that, but that SCC may not cover all the bullet points on these slides. Then you may supplement that GDPR SCC signed among the corporate group with internal rules and policies, abstracts to the relevant point, relevant clauses to address those issues. You need to have a very good mapping documents to put together all the requirements so that it can have a very easy way for the regulatory authority to review. Otherwise, if what you provide to them is very difficult, complicated for them to review, they may also reject the application, ask you to supplement in a more organized way. Next slide. So we are basically reaching to the end time of this webinar, and we're sharing with you some considerations about, going through the security assessment, the China SCC, or the security certification process. Next slide. Go back. Yes, this one. So the preparation you may want to do is first you need to run a data mapping. The data mapping will have two purposes. One, through the data mapping, you can identify whether, how many, circumstances of outbound data transfer and whether you are hitting the threshold. And also you can understand in those circumstances whether there's any compliance gap in your current data outbound transfer with the Chinese regulation requirements. And you can develop the proper mitigation measures to fill those gaps. That's purpose one. And the purpose two, which is in a long term, you can decide whether you can shrink the list of the circumstance or the types of data you are currently outbound transfer, because we all understand when there's no restriction, we collect as more data as possible to get more information to help our business operation. But because we have the data restriction in every country at this moment, we need to consider a better idea as to how to balance the requirements for information and our compliance obligation for data protection. So data mapping is basically the very first step. And after the data mapping, then you can run the PIPIA by yourself or with assistance of third parties. Regarding the PIPIA, our latest information from the CAC is that they will not expect a PIPIA purely on the legal side or purely on the technical side. They basically says we want to see a PIPIA that will address our security concern in accordance with the law. But we want to make sure there are technical and administrative measures, mitigation measures to complete the law requirements. So that's basically the key point to prepare the PIPIA is you need to combine the legal and the technical strengths to have a better balanced PIPIA that will increase the chance for you to pass the security assessment on the file for the China SCC for record with the local office of CAC. So I think we are almost running out of the time, so I don't elaborate too much on the remaining part. You can take a look, retention of the records of compliance, which give you good proof when there's a challenge. And also, work with good councils that have good resource for the updates of the China data compliance, because the PRC data law is a new set of law that's changed dynamically, and the enforcement practice also updates quickly. So getting timely update will help you to compliance with the requirement all the time. Make sure to avoid violations without knowledge. So this basically concludes my webinar today. So I think we only have, unfortunately, 1 minute to take some questions, but no worry, if you have questions that get unanswered, you can reach out to me through email or follow me on the LinkedIn, so we can get those answered for you. Thank you.
Thank you very much, Vincent. I just want to say before we go, thank you for such a informative webinar. You packed an incredible amount of information into such a short space of time. So that's fantastic. And I'm sure that our audience appreciated it. Vincent, we have had a lot of questions in, and as you say, we don't have time for all of them, but I will ask one question which I thought was quite interesting. And I'm sure that you covered some of these points during the session, but what trends do you foresee in data laws more generally? So in comparison, Chinese law with EU's GDPR?
I think, attention on the data protection will become higher and higher. Traditionally, I think, we have 3 different jurisdictions in the world, EU's approach, Americans' approach, and the Chinese approach. EU's approach is basically on recognizing the personal data as a protection to the basic human rights. And Americans' approach is basically to encourage industrial development while protecting the core part of the personal information, which is the privacy. Although there's a change starting from the CCPA and the CPRA that they are extending the protection beyond the privacy and to other, personal information. That becomes the trend in the US, and there are other states following that pattern. In China, I think China is unique because we both recognize the protection for the personal information, but also we add the national security color to the process. That's basically have a very different, combination from the US and EU. So as you mentioned, what are the trend? I think the trend will be the three systems will further interact with each other and learn from each other. Eventually, they probably will be similar to each other, because they are reaching the same goal to protect the data subject's personal rights and also to protect the security of the country.
Brilliant answer. That's really interesting. Thank you, Vincent. And I think that that's a great place to finish today's webinar. Those questions that we had sent in that we didn't get time for, they will be sent on to Vincent, but we encourage you to please do get in touch to have those questions answered and have a further discussion with Vincent. So once again, Vincent, thank you very much for your time and your expertise today. And thank you, of course, to our audience for joining us today. It's been a real pleasure to have you with us. I hope that we can see you again soon. And Vincent, I hope we can see you again soon for another webinar. But for now, I will wish you all a good day and say goodbye. Thank you.
Thank you, Dan, and thank you for all the audience participating in this webinar. Thank you.